I'm going to keep the cowbell. Jim Pettit may not know he's not getting his cowbell back. When somebody says something really good, and I really like what you say, you're going to get some friggin' cowbell. Okay. So there's that. There's that. I am deathly afraid to ask my usual opening question. But does anyone have anything on your mind? Yeah.
I actually have a question about your interview on week 3 and what you said.
I'm sorry?
About what you said on week 3 about the big.
Oh, yeah, okay.
I was just curious about how the state can actually allow the federal government to come and prosecute a crime that would normally be handled by the state.
Well, remember, you have both the federal government and the state governments can have jurisdiction over the same crime. If Congress has, haven't taken con law yet, but if Congress has a source of authority to criminalize certain conduct, like under the 14th Amendment, they have the authority under the 14th Amendment, Section 5, to create crimes for civil rights violations, okay? So, and under the Commerce Clause, if somebody interferes with the free flow of commerce, Congress can make that a crime. So if Congress has a source of authority to criminalize certain conduct, and the state has authority to criminalize certain conduct, then they can both pass a law, and a defendant could be subject to prosecution by either sovereign. And there's a doctrine called the dual sovereign doctrine that is an exception to double jeopardy. So in theory, you could be actually prosecuted by both without violating double jeopardy principles. The Supreme Court is revisiting that this term, right? And with a case where they're going to think about whether that's the right interpretation of double jeopardy. But let's say the state hasn't prosecuted, so you don't have any double jeopardy even issued. The state can say, we're going to step back. We're going to forego prosecuting this case and let the feds take the lead. Let the Department of Justice, the U.S. Attorney's Office take the lead. Under the federal hate crimes law, for the federal government to have jurisdiction, this is what Congress wrote, so in order for the federal government to prosecute, one of 3 conditions has to be met. Of relevance to us is one of those, which is if the state invites the federal government in. If the state says, we're not going to prosecute this, you prosecute it. Another one is if the state lacks jurisdiction, then the federal government can step in. So here, the state doesn't lack jurisdiction, but the state could say, the Commonwealth's Attorney and the Attorney General could say to the federal government, you take this. Our hate crimes law is not very strong. If you saw that story, you saw Brian Butler talk about this. The state hate crimes law in a murder kind of case has no teeth. It adds nothing to what the defendant would already face. Whereas the federal hate crimes law, if in a situation where it's a bias crime, the defendant, if no one dies, is subject to 10 years in prison. If someone dies, they're subject to life in prison without the possibility of parole. So there's a real teeth there. It really makes a difference in their punishment. And that's not true. I'm not going to say there's no effect to the state hate crimes law, but there's some. But there's not as much. I will add, by the way, that this Friday in the Allen courtroom, the state Judiciary Committee from the state legislature, it's a sort of a combined committee of the Senate and the House, will be holding a hearing. It's there all the time between sessions. The various committees will hold hearings to get updates on issues, consider what they might bring up as bills in the upcoming session, and they're holding their hearing here in the Allen courtroom. And one of the things they're going to be talking about is updating the state hate crimes law. One of our representatives, those of you who were at the Criminal Justice Reform panel, Jason Nemes was the moderator. He's working on introducing some legislation about this. So if you're interested, I strongly encourage you to attend that hearing. It won't be the only thing they talk about, but it's going to be one thing that's on the agenda. Is that helpful?
Yeah.
This right.
Anything else?
Actually, I won't go because we'll be in Newport.
Okay, we'll see how long I can last with this, because it's annoying.
I
Try to
tell.
talk through it. And I really can't see through these glasses at all. So those may have to come off first. All right. We had been in the middle of the Talley case, and we sort of gone through the facts, and we set up this question. I hope at least we set up this question, that the court began its analysis of the merits of holding Talley culpable for aiding and abetting, that is, by complicity, by rejecting as not applicable on the facts one potential source of culpability, right? Because obviously there could be a source of culpability, there could be a way to hold somebody culpable, but it has to be supported by the facts. What did the court say was not present here before we turn our attention to what we'll assess of what might have been present in these clients?
That they didn't act in free concert, or that it wasn't pre-planned.
Right, and that would be something you would ordinarily look for. You would ordinarily look for, did they plan together in advance? What I want to stress here is that's not required. It certainly ought to be on your checklist of things that if you see, that's going to be a dead giveaway that there might be complicity. Because one way you can aid somebody committing a crime is if you plan together. I will do this. Right? I will do this, and therefore you can accomplish your crime, or this will help you accomplish this crime. And you can count on me to do this at the appointed time, or whatever the pre-planning is. But while that's going to be a really strong indicator that there was complicity, it doesn't mean there wasn't if it's absent. Right? So it's not necessary, it's not essential. Okay? Here there was no evidence that the Skeltons even knew Talley was going to do anything. Right? That they even knew of his that there was any planning together. They didn't communicate with Talley as far as we know, and he didn't command or direct or counsel or encourage them, as the court puts it, and so there's none of that, okay? So if there's going to be culpability here, it has to be based on things, actions that he took after they began their chase of Ross, okay? So then the court asks 3 questions. What are those 3 questions that we'll try to answer under these circumstances, Mr. Williams?
The questions are, did he do any act to help their plan?
Did he do anything intended to further their design? Did defendant, we'll say Talley here, but it could be anyone as you sort of construct these questions. Did Talley do anything intended to further the criminal act or design? What's the second question?
Is it,
If so if you answer number 1, yes.
sure, is it necessary to his guilt that the defendant's act or Talley's act contributed to the design of their plan and to his death?
And why do we ask this question? I mean, what we might be concerned about or wondering about that requires us to ask this question?
Perhaps they could have accomplished it without, his help at all.
Right? Or they could have accomplished it, or they did accomplish it. Did he make an actual contribution? Is that required? Is it necessary that his act actually contributed to the accomplishment of their design? And last,
Did his act actually contribute to the death?
so is it necessary that it contributed? And if so, did Talley or the defendant or whoever we're talking about act contribute to Ross's death? All right, we're going to let you do the first question, if that's all right.
Sure.
Did Talley do anything intended to further their criminal act, their design?
Yes.
He did. Even though it wasn't pre-concert, even though it wasn't in consultation with them, he did. And how does the court show you that?
Well, when he sent his message to his friend, they say that could have conceivably helped in their plan. that at first the friend seemed to go like he was going to deliver the message, but then he stopped for some reason. And so they find that he could have given him the message as soon as he arrived, but he didn't. And so because he didn't, the court sort of assumes that he didn't meet the
The question here is it did Tally do anything intended, not did it actually, that's down here. Did he do anything intended to further their
Oh.
act or design?
Sure, yeah, so when he says, kind of at the end, his throwaway statement, say nothing to his friend, the court says that was intended to further the act.
It was intended to further the act. He knew that they were pursuing him, right? He knew that the skeletons were pursuing Ross. And he knew that that gave them a big advantage that could only be countered if,
They didn't know, or he
well,
didn't.
how could it be countered? If their advantage was.
Oh,
they-
right, yeah, so if he found out about it.
If he
then-
found out. So he takes steps that he hopes, that's his intent, whether it contributed or not, whether it helped or not, that were intended to prevent Ross from being warned. In other words, to preserve the skeleton's tactical advantage of being in pursuit, knowing where Ross was, and he didn't know not only where they were, but that they were on to him. They were following him. Okay? The only purpose of the message to Huddleston, given all that we know, was that it could act to aid them, any aid from getting to Ross. And that means the answer is question one. He took an act to further their design. Okay, good. What about question two? Someone else? What about question two? Is it necessary, we're not asking the question yet of whether it did contribute to Ross's demise, but is it necessary that his act actually contributed to demise? What is required? Comments?
Yeah, so they say to be guilty of murder.
Via complicity, good. Ms. Clements did not say to be guilty of complicity, right? Because he's guilty of murder via complicity. Because what do we know about complicity?
It's not a crime
Not a
in
crime.
itself.
Excellent. Very good. Calvin, let's get Calvin. Okay.
So to be guilty of murder, he must have aided or abetted.
And what's required for that?
So he had to be present at the commission.
Presence. I want to highlight that word. What's required is presence. And that makes me say, well, wait a minute. He wasn't in Stevenson. He wasn't on the road to Stevenson. He was back in, Scottsboro, right? How can he have the presence that the court says is required to satisfy one? Or, I'm sorry, question two.
Well, it says he doesn't need to be in actual, physical presence of the people, but he has to just be in a position to aid the commission.
He must be in a position to render aid. And this case sort of illustrates how we flexibly and broadly construe that concept, right? How you're in a position to render aid if you can communicate some information or prevent the communication of information. And this is the early part of the telegraph era. By the way, who was the first United States president to send a telegraph? Garfield. Special word of the day prize to the person who can answer that question correctly without looking it up. Mr. Williams.
Was it Grant?
No, it was not Grant. Mrs. Park. And thanks for playing.
Just say it.
Is it not Garfield Lincoln?
Lincoln is correct. Lincoln is correct. Very good. Ms. Hart, you gotta be on.
I second guessed myself. I said Lincoln, and I was like, wait, no, it was before.
See, another word to the wise. Go for it. All right. So that's very good. So that's, and we're in this era where you can start to do things from a distance. And now today, obviously you can with modern communication, social media, et cetera, et cetera, et cetera. So you have to be in a position to render aid. And what does that mean in terms of the bottom line answer to this question?
Yes, because he was, yeah, it's necessary that it contributed because you have to be in a position to render aid, so the contribution
And we know that in this case there was not pre-concert, so what's the other possibility?
Just that he helped them out, like whether they were aware of it or not, what he did still helped them reach their goal.
As it turns out, the messages reached Huddleston when?
I mean, before the death of Ross. Well, it reached Huddleston like before he could get the other message out to Warren.
And did that I'm sorry?
It reached him before he was able to just get the message out to Ross like the original one to warn him.
And when was that in relation to Ross's arrival in Stevenson?
Yeah, it was before he got there.
And more specifically? Anyone?
Was it 5 to 10 minutes?
5 to 10 minutes before he got there, okay? Now, Ms. Wall, if you were representing Tally, what would you say about this sequence? The telegram gets there, it's 5 minutes before, and 5 to 10 minutes before. What would you say in terms of this issue about whether he might have contributed to the death,
That at that point it was.
or whether it rendered aid?
That at that point it was in the hands of Huddleston, and he had no idea whether Ross had made it there or not.
I mean, you might say that, but what else might you say?
It wouldn't have changed anything?
Wouldn't have changed anything. It's too late, right? Yes, he did send the telegram. It might have been intended to render aid, but it didn't contribute in any way to aiding their plan, because the fates were already sealed, right? We knew what was going to happen regardless of the telegram. It was too late. How does the court answer that argument? How does the court answer that argument?
They say that there's several different ways that it could have played out and that we don't really know because he didn't have the chance. They say that he might have not gone and hid where he did because
That's the third question. What does the court say about Huddleston's actions and his response to the telegram? This 5-minute sequence, it's only 5 minutes. Nothing could have changed. Nothing did change. He didn't actually aid. What does the court say about Huddleston? Not about what might have been Ross's possibilities. What?
That at first he goes and he tries to deliver the message and he kind of leaves it at the hotel, I believe.
He goes to the hotel, yeah.
But he's not there. Whatever the victim's name was, Ross hasn't made it there yet, and so then he goes back and he kind of starts looking, waiting for him. But then when he sees him, he doesn't go down to him immediately.
Generally, how does the court construe Huddleston's response to these telegrams? If you were to characterize how the court characterizes Huddleston, what does the court think Huddleston's response was? Ms. McCullough,
I think the court's response
I'm sorry?
I was re-saying the question to myself.
How does the court view Huddleston's reactions and actions?
So Huddleston's the one who did not send the telegram to Ross because Calvin told him not to. So, let's see. They don't hold him responsible, do they? Because
Well, he's not
Calvin's
the
the judge.
defendant, but what do they say about Huddleston's response to, or actions in response to, getting these telegrams? Because we're trying to answer the question, did Tally's sending of the telegrams contribute to the accomplishment of the Skelton's design? And the court ties that in with Huddleston and his response to the sending of the telegram. Because that's how the court sort of reasons out its answer to this question. So this is important. The court gives a really long recitation with respect to Huddleston. Ms. Call, what does it say?
That before he got the message from Kelly, he was going to deliver it, but because he did get that message in their times, he decided not to.
And
So that means that he contributed, that the message contributed to it.
And the court sort of portrays this, maybe unfairly to Huddleston, as delaying as long as he could, right? As avoiding the sending of the message, not taking action he might have taken. This feeds into this question as well, ultimately. But the court does not think that Huddleston did anything that he might have done. He did not fulfill his duty to take every step he could have taken to deliver the message to Ross. He's not himself culpable, but it means that Talley's actions contributed to the accomplishment of the Skelton's design.
They refer to Huddleston as an officer of the law. So, and they say that like had Huddleston done his duty, he would have done these things. And they don't specifically say this, but could Huddleston have viewed it as like an order he was required to follow?
No, I mean, Judge Talley would have had absolutely no authority over him. None. Talley's jurisdiction would not have covered that. So, but in any event, they're not holding Huddleston culpable. So even if you give Huddleston that defense, we're only asking these questions about Huddleston in order to talk about the cause and effect of Talley's actions. Right? So even if Huddleston might have had a defense, great, okay, we can't prosecute Huddleston. We can still, as a factual matter, say that his actions failed to act on the telegrams in a way that helped the Skeltons to achieve their design.
So the second question, is that always going to be a question that's a bit more difficult to prove if the actual actors of the crime itself are not aware that they're being aided and abetted? Like this.
Well,
like
yeah, I mean, when you say more difficult, sure. When you obviously, if they know they're being aided, then it's more likely that the prosecution will be able to show that they were able to tailor their actions and tailor how they carried out the design to the aid, right? We'll see that actually in the next case. The next case. But you still have to prove it, and it won't be automatic just because they know they're getting aid. Just because they know somebody is acting with intent to aid them doesn't mean that the defendant's, the aider and abettor's actions contribute to the accomplishment of the design. All right, the last question. Did Talley's act contribute to Ross's death? What's the defense's position, Ms. Wall? What's the defense's position that it didn't contribute to Ross's death? We're going to see that loses. But what would their argument be?
That the Skeltons were on their way and they were going to kill him regardless of whether...
They were going to kill him regardless, right? It was completely irrelevant. Ross's fate was sealed, and nothing could have changed that. What does the court say about that question? Why does that argument fail?
That had Ross been notified, then he would have known that there were 4 men after him, and when 3 men were shooting at him, he would have had enough time to get away.
That's really good, but a little, just slightly off. He would have had time to get away? He might have. Might have. What would you say are the odds, given what actually transpired, that Ross was going to be able to survive this situation on a percentage scale? What percentage chance of survival do we have?
Very slim,
20%? You are way too optimistic for poor Mr. Ross. I'm going to say 1% chance. He was a dead sitting duck, right? He had no knowledge they were there. He was, in his not so blissful ignorance, he had no chance. what would have been the chances if the telegram had been delivered to him in the carriage?
Dramatically raises chances.
From 1 to maybe,
Maybe 75, even.
no, you're also way too optimistic. I mean,
50.
he's still facing 4-on-1,
Okay.
he's maybe unarmed.
He goes to the authorities though.
How's he gonna get to the authorities?
He's still in the cab.
Yeah, he's still in the cab, and the authorities are not in the cab with him. He doesn't have a cell phone.
Well, it said that the other guys had dismounted, one was hiding. So if he had gone in the cab to maybe where the sheriff was or something, and they.
Now you're talking. Maybe he can tell the carriage driver, keep going. I'm not getting out. Because if I get out, I'm trying to go to the sheriff, I'm dead. I'm thinking maybe it would have raised his chances of survival from 1 to 5%. He's still probably a dead duck. But notice, it doesn't matter. All that has to happen is that, or they have to conclude, is that Talley's actions hurt his chances of survival even just a little bit. That if Talley hadn't done what he'd done, that if he'd gotten the first telegram, and maybe Huddleston would have acted differently if he hadn't gotten the second telegram, that he would have not just gone to the hotel, but he would have gone to the carriage and delivered it directly to our friend Ross. And in that circumstance, Ross would have had at least a slightly better chance. And that's all you need. That's all you need, is that he contributed to the success of the Skelton's design, or in this case, the death of Ross. It doesn't have to be that it's a yes or no. Yes, that he wouldn't have survived without it, and he would have survived with it. You just have to say it would have increased the chances of success. Okay? Wherever you put those chances, if you put them at 20 and 75, or as I do, 1 and 5, the key is that they increased the chances of success, in this case, the death of Ross. Okay? Any other questions about this case?
I just want to clarify the 3 steps, just to make sure that I have it right. So is this like a conjunctive rule? All 3 questions have to be answered yes?
Keep them in sequence.
Okay.
Yep. Okay? Let's see. Formella. Tell me about this guy. Tell me about this kid.
Formella, the high school. That's a good one. He was studying with his friends at a library near his school.
Yeah.
2 hours later, they went to their lockers to get some books in the school. And as soon as they entered, they saw a group of students who said they intended to steal math exams.
Oh my God.
Asked Formella and his friends.
And what do you think I think of this case? As a, what do I do other than play cowbell?
You teach?
I teach, and one of the things I do as a teacher is
You make exams?
I write and give exams. The notion of stealing an exam to cheat causes me almost unspeakable pain. So you can imagine I am not well disposed to Formella. I imagine Ms. Richter is not either. Fair enough? Fair enough. Okay. So what did these thieves ask of Formella?
They asked him to be on the lookout and to yell a specific code to alert if they see someone coming.
Did you get your math book?
Yeah.
Flashing lights, that's a problem, right? That's a warning. And shout that up to the 3rd floor where we're stealing the exam as a code that someone was coming, okay? So how does having a lookout like this, stationed where they can give warning, how does that aid the accomplishment of a crime?
It's like a safety thing. You feel a lot better doing the crime if you know that there's someone like is just gonna walk out on you. That there's going to be a warning.
So what did Formella and his friends say happened next?
They did it. They served as lookouts, and then they went.
They served as lookouts for a while, but
And then he felt kind of guilty about it.
he felt bad. Whoa.
Wow.
oh, poor guy. And so they walk down to the first floor, they find a janitor, and what does the janitor say?
Tells him to leave.
Get out of here, kid, your school's over, right? And so they exit, and they waited outside for a while, and then the second group joins them and shares the answers with them, right? So apparently he didn't feel too bad. And they were all caught, not surprisingly, because they're not very bright. And he admitted his involvement in the theft, and he's charged with criminal liability for the conduct of another, i.e., complicity in the theft. Okay? And on what basis does he appeal?
He argues that the trial court erred in failing to make findings of fact relative to the timing of his withdrawal from the theft, completion of theft, because without such findings, the trial court would not properly apply RSA 6260.
Withdrawal. And this is a natural issue to arise in complicity, because the question is, if you've given aid, can you withdraw that aid and end your culpability for the conduct of someone else? Can you withdraw and end your culpability for someone else's conduct? Well, what does the statute say?
The statute says it has three parts to it. The first part is you must act as accomplice in the commission of the offense.
Did Formella do that?
Yes.
Yes, he sure did. And this occurs when?
With the purpose of promoting or facilitating the commission of an offense, he aids or agrees or attempts to aid another person.
So that gives us our mens rea, with the purpose of promoting or facilitating the commission, in other words, the success of the commission of the offense. You agree to aid another in planning or committing the crime. Does Formella have any leg to stand on that problem?
He helped in, not in planning, but in committing.
In committing, so that's the second X against Formella. So far, in other words, not so good, right? On the other hand, the law also says that a person is not an accomplice if
He terminates his complicity before the commission and wholly deprives it of the
Okay. terminates prior to the commission of the offense. Argue for Formella that you meet that element of the withdrawal statute.
No, he didn't terminate it before they found
That's arguing for Formella? He needs a lawyer who's on his side. Mr. Webb?
He left. I mean, he was like serving his lookout, and before they actually stole the items, he just left.
Formella, the argument is Formella left his post, so he's a deserter also, by the way, as a lookout before the exams were stolen. And that is the act that constitutes commission of the offense. So at least we can say that the facts might support Formella on that element of withdrawal. Everyone see that? Is that enough?
No.
No.
No, that's not enough. What else do we need?
Gives timely warning to law enforcement authorities or otherwise makes proper effort to prevent.
You skipped something.
Wholly deprives.
Wholly deprives.
Of
He
effectiveness.
terminates his complicity prior to the commission of the offense and wholly deprives it. Go ahead.
Of effectiveness in the commission of the offense.
Yeah, go ahead.
Or gives timely warning to law enforcement officials.
That's an or, so as to these two, you don't have to have both for Formella to win. Or, what was it again?
Timely warning to law enforcement authorities
Yeah.
or otherwise makes proper effort to prevent the commission of the offense.
A whole long list of choices from which Formella can choose and get his withdrawal defense. Did he wholly deprive his actions of their effectiveness in helping the commission of the offense?
No,
Why not? He left. They didn't have a lookout anymore.
he left after a while.
But that's going back to number one. Let's assume that it had not occurred yet.
He had to undo his initial, agreement to watch out for.
Put yourself in the position of the thieves. Thieves. He's abandoned them, but
They don't know that he abandoned them?
so they still think we got this shield of safety, someone's going to warn us and alert us if there's a problem. So that what assistance does his action as a lookout render? It renders the assistance of confidence. Now, it may have been misplaced confidence, but that doesn't really matter. They still thought they had the effectiveness rendered by his assistance. And if all that he did was leave, it did not wholly deprive, what could he have done that would have wholly deprived them of the benefit that they thought they had?
Go and tell him that.
I'm sorry?
Go and tell him that he's not gonna be there to look at him.
He needed to go and tell them, oh, I've had second thoughts, this is wrong, I'm not going to be involved anymore, you guys are on your own. That, at least arguably, would have deprived his role, his assistance, of effectiveness in helping to accomplish the commission of the crime. So he didn't do this. Just by leaving, not enough. And these are even easier is, did he give timely warning to law enforcement? Certainly didn't do that. And then otherwise make proper efforts to prevent the commission of the offense. And